So I think that Tammy, maybe Lewis, but I think everybody else that's here right now has been in one of my other classes this week. Um, so, well, here's Jessica. She hasn't been. So for everybody who's been in one of my classes, or two or three of my classes, this is going to be some redundancy, but better than to have a few people not know what I'm talking about here. I have, I'm going to share my screen with you, see what I can bring up here. Okay, so what I'm hoping that you can see is a Word document that says COVID-19 Zoom class meeting restructure. Can someone tell me that they see that?
Sure can.
Yes.
Great. Okay, so those of you who've seen it a bunch of times, maybe you can zone out for a minute here, but basically what I've said is that in response to some students being overwhelmed, and I understand, the normal overwhelmness of attending community college, having a family, working, and attending school is, pretty overwhelming for some people at some times. And when you add in COVID-19, it makes it even worse, or could. So what I've done is to say, well, there's two options on how you can get the attendance and participation points. One is that you come here for 30 minutes. And, if you have to leave after that because you've got some things that are going on, okay, the new system, the college is going to record time, just like you see here. This is from the, I think the Monday or maybe Tuesday. This was the Tuesday civil litigation. Your names would be over here, your login time, your leave time, and the total number of minutes. And you can see, I don't know why, but for sometimes people are listed at 1 minute. I haven't seen anybody who was only here for 1 minute and never came back. Usually they're back for 80 or 90 minutes. But the key thing here is that I don't have to take attendance anymore because it's going to be taken by the Zoom system and give me a report of who all attended and for how long. So if you attend for at least 30 minutes and then you do a little enhanced discussion by making your initial discussion post and then interacting with at least two other students by posting two reply posts. So you can get the attendance points by attending for 30 minutes and doing your initial discussion post and engaging in at least two. So that gives you one option. The other option is to join the meeting and stay for the 75 minutes, which is an hour and 15, and you just make one, like we have been doing, one initial discussion post with no requirement that you have to do the other. Now, the meetings are recorded, so if somebody didn't show up until 7:40, or well, I'm sorry, tonight we're at 5:30, so if they showed up at 5:40 and missed the first 10 minutes, it's not required that it be the first 10, it's just required that it be 30 minutes. If you missed the first 10 minutes, hopefully you can see the first 10 minutes the next day when the recording, so you can see what you might have missed. So that's how we're going to change participation points. The other thing is simply something that I've changed about the quizzes. From now on out, you have 3 attempts at the quiz. And the first attempt, you must get at least 50% of the questions correct in order to get a second and third. So I want people to take the first attempt at the quiz a little more seriously than I have seen some folks doing. Now, having said that, there are not very many people that I think haven't typically gotten 60% on the first attempt, and especially if I can get the questions posted up in advance so that you have the ability to see all those questions as you read. So take a look at this attachment, which is on the announcements page. So here's what the kind of restructured class will look like. This will be the last time we'll talk about this, but basically, like this class starting at 5:30, the first 10 minutes is welcoming you and, talking about the agenda. Then the next, 10 minutes is to kind of review the weekly discussions, quizzes, and assignments to make sure that if you've had some questions about that, you can let me know what your questions are or what you want me to discuss so that by the time we finish, we have clarified that. Now, I'm hoping to always have posted at least an hour before class, what I'm calling the class notes. And what the class notes are is just a rundown of those, what the discussion, what the assignment, and what the quizzes are going to be. Excuse me, I need some more water. So there's an error here because I've said that's going to happen from 5:30 to 6, and that's actually 15 minutes instead of 10. So at the end of that, at 6 o'clock, well, if you have to leave, then you can leave, and I'll have a record that you were here, and you would get your participation points. Then for the next 15 minutes, we'll go to breakout rooms, and that's called a high impact practice, a collaborative learning experience. The college is really big on that, and so we'll do that for 15 minutes, and then come back for 30 minutes of a deeper lecture. So the class would then end at 6:45. So those of you who this is the first time you've seen this, or anybody, do you have any questions about this change in the structure? If you do, please just speak up. Okay, I'm going to stop the screen share because it sounds like everybody understands that, right? So it's Tammy, that's the first time I think you might have seen it. Yamara, is that the first time you've seen that or heard that discussion?
Yeah, I have seen that before.
Oh, okay. I'm sorry then.
Sorry.
So Jessica, that may be the first time you've seen me go through that, and Bella may be the same thing. So do either of you have a question about that change in the structure of the class?
I don't. Yeah, you've been doing it across all the classes I've had with you this week, so I'm pretty good with how it's working out. It gives everybody options.
Great. And Jessica, how about you?
Yeah, that makes sense to me. I like the new format.
Okay. So why don't we then move right to my interest in finding out if you have any particular topics or questions that you want to make sure that I cover before we conclude the evening. So Tammy's gotten registered under the new system, and so now when she comes back, it hopefully won't be the hassle that it was, but I think you probably all had to go through that registration. It's only a one-time thing. But so does anyone have a question about where we're headed this coming week?
No, sir.
Louis, did you have something?
Oh, I was saying no, sir.
Oh, okay, great, thanks. Okay, well then, let's go back and do the screen share again. Not seeing what I want to see here. So this week, when we look into the assignments, you're going to see that this is basically a FIRAC brief or something very similar to a FIRAC brief. And this isn't one of the attachments that you're going to have in your course shell. And this is the grading rubric. So you see, if you look over here on the left-hand side, it talks about the mechanics, statement of the facts, the procedural history, the issue, the rule of law, the analysis, conclusion, procedural result. So this whole thing, if you got a perfect score, would be worth 75 points. And you can see, as you take a look, let's say at the facts, you go across here. If you did what it says here, then you should get between 9 and 10 points. So the material facts giving rise to the dispute, those facts essential to the outcome of the case expressed in generic terms, the unimportant facts are left out. So that should get you 9 to 10 points. If you did none of that, well, then you're going to get a score that was going to range between 0 and 7.99. I think you've probably seen this grading rubric before. But does anybody have a question about that grading rubric and how we intend to apply it?
I do. Houston
Okay.
does.
Okay, Houston.
So for the citations, because I hate doing the footnote citations. I can if it's necessary, but are you okay with the in-text citations being hyperlinks?
Yes, I like that, in fact.
Okay.
I mean, I know other instructors feel differently about that.
Yeah, Mr. DeVoe, he's very particular about his footnotes. So I was just wondering if you'd be okay with it.
Yeah, I would actually prefer, because it's right there where you can see it. You don't have
Right.
the page down. Sometimes if it's a paragraph that's at the top of the page, okay, you got to break your train of thought. You scroll to the bottom. I mean, most judges probably like it that way. I'm not a judge. I like it simpler. So yes. Does that
Excellent.
help
Thank
with
you.
that explanation about that?
It does. I also feel it's a lot more, I feel it's more professional to do hyperlinks in text. So thank you for that.
Well, when I think they developed these ideas about footnoting, didn't have hyperlinks, and so you were turning in a document that was not digital, and so okay, maybe it made more sense then, instead of having maybe a half a sentence with the name of the case, the citation, the year it was issued. Maybe it was simpler to read by scrolling to the bottom. But here, when you can hyperlink it or just put it in there, I think that will become preferable for some people. Like I've said before, really when you're doing something like this, whether it's a Fire Act brief or a memo or whatever it is, the guiding principle is what does your audience want? If your audience is a judge and she tells you what she wants, well, that's what you should do. If your audience is your employer, well, then that's what you should do. So think about it in terms of what does the audience of this document want? Anybody else with a question about the Fire Act brief rubric?
Are you still on the page of not caring about procedural history, or should we include that?
Yeah, I'm still on the page of not caring about that. You're going to
Okay,
find a
sweet.
bunch of people who are, but to me, what this assignment, and you see it in all of our paralegal case courses, that this is a critical thinking and legal analysis exercise. That doesn't mean we throw out spelling and citations and format. But to me, the essence is being able to identify the relevant facts, then stating the issue. Another way I think about the word issue is it's the question that this case, or questions that this case is being illustrative of. So to me, getting the relevant facts, being able to state the issue, generally you're looking at, okay, it's a question. And then, okay, the answer to that question is the rule. and basically the rule of law. So to me, that those are some of the critical things. I think the hardest part is the analysis part, trying to understand why the judges ruled the way they did, trying to get insights into what persuaded them or what didn't persuade them, what may have persuaded the minority. You know, the value of the analysis is, okay, you can go back and look at a case that's 30 or 40 years old, see what the analysis was, see what the judges said, what persuaded them, and then think of it in terms of, well, is this a case that could be ripe to be challenged? And might the appellate courts come with a different opinion? Because number one, maybe a change in judicial philosophy, change in the members of the court, definitely, you know, a change in our culture. So understanding the thinking process of the majority and the minority can give you some idea about, well, is this something, you know, that we think is wrong? We have a client who thinks it's wrong. We have a client that needs to have this prior decision overturned. So to me, those are the critical things. You know, it's important to know whether or not the case was sent back, whether it was affirmed, reversed, remanded, and a new trial granted. You know, that's important to know. And you know, if I told you that we were doing the signature assignment, now that anybody know what I'm talking about when I say this is the signature assignment of this course?
Kind of
I
like,
guess the one,
oh, go ahead.
I guess just the one that's worth the most points, like how we have Missouri versus Jenkins coming up soon.
Yeah, that's one of the things is more points. It's worth more points. Anybody know why it's worth more points?
Because there's not that many assignments to begin with.
Well, that's a very
Be honest.
practical. Here's the behind the scenes view of why we do this. There's a big movement in education to say, okay, we want you to assess the student learning. We want, and this is a national thing, the accrediting bodies that accredit colleges have fallen on this. They're saying, hey, wait a minute, you know, you colleges are getting millions, well, maybe billions of dollars from student financial aid, and you're building bison-shaped swimming pools and $300 million stadiums. But can you show us that there's an improvement in the learning of the students? So, that's this huge movement about it, what's called assessment. And you know, without beating one of my least favorite topics to death here, you know, what they want is to be able to show improvement from one kind of an assignment to another. So maybe you did a signature assignment on a Fire Act brief and introduction to law, and now you're going to do one in legal research and writing. And hopefully, if you did the same assignment, there'd be substantial improvement across the board. Now, that's what you see on the surface when you see these, what the instructors will talk about as a signature assignment. What's supposed to happen after that is we go, okay, yeah, there was improvement. Then comes the hard part for the instructors. Why was there improvement? Was it just a matter of repetition? If there wasn't improvement, could we improve the teaching methods? Are things we could do? So that's really what this is all about. So when you hear a signature assignment, yes, it's going to show up as being worth more points. Generally, it's going to be, in our department, it's going to be 75 down here. And what we're looking for is improvement. We look for, okay, this concept was introduced in, you know, PAR 115. It was reinforced in, let's say, property law. And then, you know, at some other point, it was mastered. And so that's what this is all about. Does that put you to sleep, or does that create some more questions?
No, that's actually a very good explanation.
So, so whenever you see those words and you see this rubric, that's really what we're talking about, is a signature assignment. Now, I wanted to take a look for a minute. You've probably seen this. I mean, I know when I taught 115 introduction, we went through this often. And so basically, it's how to do it, talks about the breakdown, the fact that we want generic instead of, a sort of a flowered up version with adjectives. So when you say, hey, a good statement here of the facts was buyer sued seller for rescission of a contract to buy a car. That's the legalese way that we would want to distill, what the facts were. Because if we put this particular sentence in a Google search or a LexisNexis search, we might find a lot of cases that are similar. So that's why we want it to be generic. We don't want Bob Jones sued Sally Smith to break a contract for the sale of Sally's red Ford Pinto. If you could put that in, you'd only find one case, the case that involved those two litigants. So taking out things like Sally's name, Bob's name, color of the car, even the fact what kind of car it is not really relevant. And so that's when we say generic. Is there anybody who hasn't seen this FIRAC brief method before, this document? It's okay to.
I have it pinned to my taskbar.
I thought you were going to tell me you've tattooed it to your chest or something.
Oh, no, that'd be extreme.
That's extreme. Well, so if you look at the bottom here, this is a sample of the format. So those 4 or 5 points that deal with format, okay, we want your name over here, we want the case name, citation, and then we want, this basic format. So you could create a template of that if you wanted. Anyway, this document I've moved it to the top of the announcements page in the course shell. So if you need to review it, that's where you'd find it. Now, what does this say? Lynn Chase's Zoom meeting in 5 minutes. Holy cow, what is that about?
Don't be late.
What time is it? I think I'm going to put that on snooze. Goodness gracious. Anyway. So I'm going to see what I can do about bringing up the course shell. And then sharing that with you. Well, that's not what I want. Okay, finally. So I want to go over and look at the assignment. So the assignment that was is due today was basically restructuring that PowerPoint. But the big assignment for next week is to to outline a legal memo. And so I wanted to kind of dig into this a bit. So what you're going to see when you open that up, and has anybody opened that up yet to take a look at next week's assignment?
I have.
I'm going to, okay. So I'm going to send you into breakout rooms in a little bit to go talk about this, but basically you're going to look at the appendix in your textbook, Appendix B, page 444, and it's problem number 9. So that's what you're going to use as sort of the basis. So it's on top of page 445. It's problem 9. It gives you these facts and law. If you look over on the second page, the next page over, 446, you'll see that there are some references here to cases that could help you with this concept. We're talking about 42 United States Code section 1983. And there are a couple of cases that deal with that. One is Morris versus Frederick. The other is Tinker versus Des Moines Independent Community School District. So what you're going to do here is this is not actually creating the Fire Act brief. It's going to lead you to creating a Fire Act brief. So what it really comes down to is it's a legal memorandum, and that memorandum, it gives you sort of the outline that you're going to use. You can do some of the research. So what we said here is there is no template, and it's not going to be like preparing a Fire Act brief and listing the facts and the issue and the rule, but you know that that's where it's headed. So you're doing the research, you're creating what could be called an outline. Now, Houston, since you looked at that, did you have some questions when you saw that the first time?
No, I've read stuff like this before. It's just a matter of pulling out the relevant information and plugging it into the Fire Act section it belongs in, and then doing research on it.
Yeah, but you're not really doing the complete Fire Act brief.
For this assignment?
Right.
Oh.
If you look at chapter 13, let's see, what page is that on? Okay, so chapter 13 begins on 297. And so it talks about creating a memorandum of law. And so when you look at chapter 13, you'll see that really it's more of the initial research. And if you review those pages, you'll see it's if you looked over on page 303, that might give you a good idea of what a sample outline would look like. So basically, it's like your first step in creating a Fire Act brief. Now, I've gotten this message again that wants me to start a Zoom meeting. I think I'm in a Zoom meeting, and I'm going to dismiss it. And I'm really concerned about what will happen when I do that. But if I vanish, we'll try to come back in here and get started again. I'm going to hit dismiss this thing. And hopefully nothing bad will happen. So I've got a PowerPoint here that I've updated, and hopefully this might supplement what I just talked about. Okay, so I've got to unshare and reshare that. So this is week 5, and if you look at this chapter, you'll see something similar to the not sure what that was, strange noise. You know, these are the learning objectives that you will see here. One is to define the purpose of an office memorandum. The other is to define, to identify the purpose. So it's kind of similar, but not identical. Describe the proper style and format of an office memorandum. You're going to list the elements of an office memorandum and you're going to write it. Now, I think this is not the particular one that I wanted to share with you. So I did an update of one here. Let's try this. So yeah, this is the better one. Basically the same material, but just a little, I think, a little easier to read. So an office memorandum is a research document. That's kind of as opposed to the finished FIRAC brief. So think of it as a research document designed to provide the information about a case or a matter. So it's a research document instead of a finished FIRAC brief. So you're going to be asked to research a question and your answer will be provided in the form of a written memorandum. Here's the basic difference. It's an internal document, meaning it's prepared for use within the law firm or the corporation or agency. It's not to be provided to an outside opposition or to a court. So that's the biggest, I think in my mind, one of the biggest determiners of what's kind of the difference between an office memorandum. Well, it's internal. So, the objective should be to inform the reader of the findings of your research, what you've located, and not interjecting your opinions, not at this point trying to be persuasive. You're trying to be specific about it. And its format should have a heading. So that's similar to saying, the facts in a FIRAC brief, and that would be easy to transition. The heading would become, the relevant facts. Then you're looking at, okay, the issues or the question that's being presented. Then we want a brief answer to that question, and it might be that there are more than one issue, more than one question. So you might have brief answers. Then a statement of the facts. If there are applicable statutes, there's where we'd want to see that. And then kind of an analysis or discussion, and then your conclusion. So it's similar to a FIRAC brief, but it's informal. Does that make sense to anybody about the distinction between the FIRAC brief and this memorandum?
Yeah, it makes sense to me. I've done a couple of them in intro to.
Okay, good.
Right, so we're just because I already have some outlines for office memorandums that I've had to write for criminal law and stuff. Just I can use that and then follow that to do this assignment.
Yes. So
Okay.
we've just gone through the FIRAC method, and you've all done it, and okay, it's facts, issue, rule, and analysis, or sometimes people would say application, plus the conclusion. So here are some tips for writing the memo. One, do not use first-person pronouns. Avoid statements such as the next case I found, or I believe. You take that personal first person out of the equation. Secondly, use complete Blue Book or appropriate citation form so that if the memo becomes the basis for a document submitted to the court, you won't have to return to the law library and track, down those sites. You've got them there. So that's a good tip. In some law firms, you're going to see that they maintain, banks or files of previously prepared memos. So it's a good starting point. So before you begin a new project, you want to see if the firm has a memo bank to see if, okay, there's already a memo on the topic. Maybe it's 10 years old, so it needs, of course, to be updated, but at least it gets you a starting place. Another set of tips is some attorneys prefer that all cases cited in the memo be photocopied and attached to the memo for, quick reference. So you want to see if the individual that's, that's assigned you this memo, what they want. And, I can hear Houston thinking, well, why can't I just give them a link? And I think that would probably be good as opposed to running the copy machine. And in today's world, where 10% of the lawyers are in the office and maybe 90% of the support staff are working from home, a link would probably make a whole lot more sense. And so then you're going to gather all the documents and materials and have that all together before you write. So after you've got that, then we want to shepherdize or key cite. So you want to provide your supervisor with copies of cases that negatively affect any cases that you have found. So who can explain to me what shepherdize or key cite, what does that mean?
Looking up precedents or like precedents, because I've seen it on LexisNexis. They have the shepherdize option.
Have you used that option before when you've seen it?
No, sir, because I wasn't sure what it was.
Okay. Well, shepherdizing or key citing, those are kind of the trade names or that these paid research applications provide. So LexisNexis has shepherds on citations. It used to be a huge set of books, and it looked like Egyptian hieroglyphics because it would just be 3 columns of very small print with case numbers. Excuse me. And then there'd be a little symbol indicating whether it's been followed or overturned or something like that. So you find a bunch of cases that are on point or that cover the concept of your research. And then what you need to do is to say, well, okay, here's one that I really like, and it's a Colorado case, and we're in Colorado, so this case is likely to be binding legal precedent. And so my lawyer is going to be able to go to court and say, Your Honor, this case is well-established Colorado law. Here's the citation. Our client's facts and situation fit directly in, 100% right on point. You'll hear old-time lawyers, maybe not so old-time lawyers, who will say this case is on all 4 points. It's all, like a horse. It's got 4 legs. It's all 4 points. In other words, this is exactly the same case, or you're trying to convince the court. It's the same case that was decided 15 years ago by the Colorado Supreme Court. Well, how do you find that out? Because there's thousands of cases. Well, Shepard's has created a data bank that would search all that. So if you we're looking at a case and then you hit the key cite link or the Shepard, it's going to look and see if that case is still good law. There'll be indications about whether it may have been overruled. So for example, the one that I keep using because it's I guess it's one that's kind of burned into my mind. But if you look at Plessy v. Ferguson, the Supreme Court saying separate but equal was constitutional in 1895. If you tried to cite that to a court, the judge would wonder what's wrong with you and wonder whether they should ever trust you again. And the opposing counsel is going to rip you because, well, you're citing something that's been overruled by the Supreme Court of the United States in 1952. So it's not good law. So that's what shepherdizing or key cite is about. And if you're using Google Scholar, you can see there's a link that you can see where it's been cited and indicates, where it's been followed. But Google Scholar it's good and it's free and it's evolved and it's going to continue to evolve and improve, but it's not as reliable. You have to do more work, I would say, to know for sure whether that's good law. So if you hit that shepherdized link, it's going to tell you whether that case has been followed and what courts have followed it. And it's going to tell you if somebody's overruled it or if it's not been overruled because it's been in another state or another federal district, but yet it's not been cited or it's been, it's not been the law of the land in that section of the country. Does that make some sense?
That actually helps a lot. Thank you, sir.
Yeah. So it'd be great next time you have a chance and you're in LexisNexis, hit the Shepherd-Dies, or if you're in Westlaw, I think it's Key Cite. Hit those links and see what kind of information it gives you, because your lawyer, when you show your lawyer that, okay, here's a case that's on point, it's on all fours, it's good law, we should win. Or here's a case that's on point, but if the court follows it, we're going to lose. So we have to figure out how we can distinguish the facts in our case from the facts in that case and can say to the court, this isn't on all fours. This is different. That we can distinguish the facts of our client's case from those in this case that the other side is going to be citing as binding legal precedent. So this is how you verify that what you found is current and up-to-date law. So you want to save those memos that you prepared and others you come across in your own, I would say, mini memo bank, because you will be surprised that if you're working in a particular area of the law and you've been working in it for a while, you're going to come across the same issues over and over again. So it's going to be a great way to give you a good starting point for your new project. Okay, so
Thank you. I appreciate it.
yeah, let's see if I can unshare this and interesting. Okay, so we're back at the with the group here. I probably talked too long. I wanted to get you to get some time into a breakout room, but I think we'll still do that. I'm going to see if I can share the notes. Did anybody have a chance to look at the class notes that I put up?
Not yet.
For this week,
Okay.
I did.
Okay, so I'm gonna get out of this and go back to the announcements page, and I've made them as an attachment. Probably gonna have to reshare them when they open. Yes, makes sense. So this is what you would have seen. This kind of follows with that PowerPoint that I gave you, but in the discussion, I have created a hypothetical case, not a real case, and we've called it Speaker versus South Bay County School District. When you look in the discussion, you're going to see sort of a rough hypothetical. And basically, we're asking whether Susie has a cause of action based on 42 USC 1983, which just also happens to be the same topic that you're getting in your memorandum of law. So you're going to read chapter 13, and then you're going to take a look at the quiz. And, as I've said before, here are the quiz questions. There are 10 questions. It looks like most of them are true, false. So this gives you kind of a roadmap of what you should be looking for. And then here, of course, is the information that I just gave you about, finding the assignment on, problem 9 in your course textbook. So does anybody have any questions about where we're headed this coming week?
Yes, sir.
I have a couple questions about the assignment.
Okay.
Let me pull up the instructions real quick. Okay, so I'm really confused by create an outline for a legal memorandum. Are we creating a legal memorandum? I mean, is that what this assignment is? The finished product, will it be a legal memorandum? Because I'm really confused by that outline for a legal memorandum.
I would know you're not going to complete a Fire Act brief. You're going to complete the research for a Fire Act brief. In a way, you could look at it like your notes that you've amassed. So it's an outline that you could move each of those areas from your outline into the Fire Act brief, but it's preliminary. Does that help at all?
No.
No, definitely not.
Can anybody help?
So one thing that's confusing me is if I was going to write an outline, I would write it exactly like a Fire Act, because that's the most logical outline that I could do, is separate the facts from what the question of the case is. And
Right. Well, but my
I think what
confusion is
Mr.
that I actually have outlines for office memorandums that is specifically about a client's case and the facts needed for that particular, what we need to prove, the analysis of, whether or not we should take the case, and what kind of statutes you look into, whereas a case briefing is like about a specific legal case. That's what I'm confused about.
I think what Mr. Chase wanted us to do was, he said to look at page 303, and I found the example that he was looking at, and it looks completely different than like any brief or memorandum. So I think if you look at that page, you'll be able to get a little bit of help from that, if I'm not mistaken.
Yes, I mean, it is preliminary research. If you started from zero, okay, you could say, well, let's brief this particular case. Let's brief Missouri versus Jenkins, and you go look at Missouri versus Jenkins. But here you're starting with a client who has a problem, and there are facts that you can gather about that client. And so you go, okay, now let's do some research about this question. So the memo is an inter-office document in which you've done your preliminary research. It's going to grow into and develop into a Fire Act brief, but it's not starting off with a particular case in mind. And so your research could identify a dozen cases. Maybe one of them is supportive of your position and 11 are opposed. So you need to dig in to see, okay, well, what's the thing about these cases that are similar to our fact situation, our fact pattern, and what things can we distinguish? And so you're giving the lawyer the benefit of this research. So here are the cases opposing. Here are the cases that are kind of neutral, or they support. But this is a case from Alabama, and we're in Colorado, and Alabama is not binding legal precedent on this issue in Colorado. So you're gathering all of that. that could eventually culminate into a FIRAC brief that that's going to be used to submit to the court on a larger opinion. Can anybody give me a thumbs up here that they understand what I'm doing?
I
Thumbs up.
think I understand what you're talking about. It's just my brain is just so freaking logical that I actually have an outline for a memorandum that covers that with a statement of the assignment, the issues, like what are the questions that need to be addressed, the brief answers to that, facts gathered as far as like stating all the different statutes and cases that I found related to this laid out, and then an analysis of the issue at hand for this client. That can I use that, or the
Well,
thing that
I do think. I think what we're looking for here is,
okay.
as opposed to me saying brief Missouri versus Jenkins, I'm saying here are some facts. Find some cases for me. You're going to do that research
Okay.
and put together a memo,
Okay.
which the lawyer may eventually create a FIRAC brief.
Okay. So that makes sense. I just had to say it out loud. I appreciate that. Now I understand.
No, that's good.
So I can use this outline, and that'll cover what you're looking for.
I think so. Let me get a reaction. Is this getting clearer or more muddy? Thumbs up or down? Go over there to the reaction bar. I don't know.
Thumbs up, sir.
Thumbs up. Okay,
Oh,
there's a
thumbs
thumbs up. Here's where I think I'm at. Although it's kind of sticking with the same color, I didn't really want to show up. Okay, well, let's see if we can go into a breakout room for a few minutes and maybe kick this around among yourselves, and see what that does for maybe getting this a little more clarified. So we've got what, 8, 11? Let's do about 3 groups. Well, that's too many people. So we're going to have 3 groups that'll have 3 to 4 people. So I'm going to create those rooms, and this 8 minutes with a minute warning, which makes it 9 if you stayed and forgot about where you were, and we wouldn't have to have someone come rescue you. Does that time work?
That sounds good.
Sure.
Okay, let's try that.